Hello, welcome to Civic Literacy Workshop number 2 at Florida Atlantic University. My name is Dr. Jennifer Biebergell, and I am the Associate Dean for Retention and Academic Support here at Florida Atlantic University. I want to preface this workshop by saying I am not an attorney, I am not a constitutional lawyer, I do not know a significant amount of material about the constitutional landmark Supreme Court cases that we're about to cover. However, I am competent to be able to present these cases in a way that you can learn them to pass the civic literacy exam. So let's go ahead and get started. So we're going to start today. We have about an hour together, and we're going to review the civic literacy requirement, get a little bit of what you already know. Then we're going to review 22 landmark Supreme Court cases that you are very likely to see on your civic literacy test. Then you'll have an opportunity to take a practice test, and we'll see how you do. And then we'll give a reminder about our final workshop and how to sign up for the test. So just briefly, the civic literacy requirement is something that is across all of the Florida state universities and state colleges in order to earn an Associate of Arts or a bachelor's degree. There are multiple ways that you can earn this. You can take our Government of the U.S. POS 2041 or U.S. History since 1877 AMH 2020 course. If you were, when you were in high school, you could have passed with sufficient scores on the AP test. We also have a CLEP test, which is a college level examination for proficiency, which is about $100 on U.S. government. And if you pass that, you satisfy the requirement. But the quickest and easiest and free way to complete this requirement is by taking the free civic literacy test offered through the FAU Office for Testing and Evaluation. It is a 100-question exam. You only need to get 60% correct, so 60 questions out of 100 in order to satisfy this requirement. And the workshops that you are currently participating in were designed to help you pass that test and satisfy this graduation requirement. The test is free to take, like I said. You go to the FAU testing website, fau.edu/testing, and click on register for your exam. The test is offered Monday through Friday, every day that we are open. Every hour from 9 to 2. You do get 2 hours to take the test. However, you can leave as soon as you are finished, and most students finish it in well under 1 hour. And you do get your scores as soon as you are done. So let's jump right into these 22 landmark Supreme Court cases. So I'm going to ask you to take a minute and look at your screen, or if you've printed out the handouts already, to take a look and see how many of these 22 cases you already know. Maybe there's some that you've heard of, but you don't really know many details about. Maybe there's some that you are familiar with. So kind of get a number in your head. If you're familiar with fewer than about 15 of these, you are in the right place to listen to this workshop. So within the next hour, you will feel confident that you know the majority of these 22 cases. So before we begin, if you have not already, on the Canvas site for this civic literacy practice course, you can download the practice test, as well as you can download this PowerPoint. If you want to print out this PowerPoint and take notes on it as we're going through the cases, that might be most helpful for you. So you feel free to pause this recording and come back when you have printed the cases if you would like to do so. So we're going to go through these cases. When we think about what the Supreme Court can rule on, remember the Supreme Court is one of the 3 branches of our government, and the Supreme Court only looks at cases to determine whether or not they are in violation of the Constitution. So it might be a concept within the Constitution, or it may be questioning whether something violates an amendment to the Constitution. So I've aligned these slides based on the cases, based on the amendments that they follow, the concepts that they're following, and at the end we'll have a review by amendment and concept. So the first case we're going to talk about is Dred Scott versus Sanford, and this was in the 1800s, just before the Civil War. So Dred Scott was a slave. He was a slave in a slave state. In 1820, there was something called the Missouri Compromise. This you might find on the exam as well. The Missouri Compromise basically declared where free states were and where slave states were. So anything south of a certain point was considered a slave state, anything west of a certain point. It determined whether or not you were going to be in a free or a slave area. So in the 1800s, Dred Scott was a slave, and his family, his owners, moved to what present-day Minnesota, which was a free state. Subsequently, his owner passed away, and he said, oh, my owner died, I'm in a free state, I'm a free man. The owner's widow was moving back to a slave state, and he says, I'm not going, I'm not a slave. So he petitioned the court, and the court found against him, found for the widow that he was still a slave. This went to the Supreme Court, and when we're looking at these cases, most of the cases start at a lower court, and it is only through an appeals process by losing and then appealing and losing and appealing that you get to the Supreme Court. There are a few exceptions where it goes directly to the Supreme Court, and we'll talk about those cases. But in this case, it went to the Supreme Court, and the Supreme Court refused to even rule on this case. And it is because they said that this slave, Dred Scott, was not even considered a person. He was not a citizen of the state. He was not considered he was property, not a citizen. So they could not rule, because you rule on behalf of people, and they could not make a ruling for Dred Scott. I like to remember this. I think in modern standards, we think this is what is considered a dreadful ruling, to say that because this person was African American, because he was a slave, he was not even considered a citizen or a person. When you see questions on the civic literacy test about this case, they might ask you about which case nullified the Missouri Compromise or declared it unconstitutional, because this is basically saying the court is saying that Congress did not have the power to ban slavery at this time. So it nullified the Missouri Compromise, saying that that wasn't constitutional, and it said that Dred Scott was not considered a citizen. Staying on this theme of slavery and race relations, we're going to move to Plessy versus Ferguson. Plessy versus Ferguson is the first of several 14th Amendment cases we're going to look at. So if we remember, in the 14th Amendment, we talked about this concept called equal protection. So it is saying that the law is equally protecting all people, no matter what their background is. So in this case, race, right? So in Plessy versus Ferguson, Homer Plessy, this was in 1890, Homer Plessy was 1/8 African American. At the time in Louisiana, they had what they called the Louisiana Separate Railcar Act, which required that white passengers rode in the white car and non-white passengers rode in a non-white car. Being 1/8 black, Homer Plessy decided that he was going to purchase a first-class ticket in the white rail car. He got on the white rail car and was told, no, he cannot ride in that car. He had to move to another car for non-white passengers. He refused to move, and he was arrested and fined and placed in jail. He fought his arrest, and his case was, when he lost his case, it went up through appeal to the Supreme Court, and the Supreme Court looked at his case and said that Homer Plessy did not have the right to ride in a white rail car, that the law was upheld, and racial segregation is constitutional under the separate but equal doctrine of the Constitution. So basically, separate but equal says, so it's not like we said you can't ride in the rail car, you just had to go into a separate rail car that they considered to be equivalent to the white rail car. So Plessy versus Ferguson in the 1890 upheld racial segregation and said separate but equal is constitutional. Do you know which case overturned this idea of separate but equal? It's probably a case you may have heard of. Many of you may have heard of it. Brown versus Board of Education. So this was in the 1950s in Topeka, Kansas, and Linda Brown and her sister were young children, Black African-American children, and they had to go past a white school, across railroad tracks, through a bad neighborhood, in order to get to their, quote, separate but equal school. So the Brown family sued and petitioned the court to say, we want Linda and her sister to go to this local school that was designated for white children. The court said, no, separate but equal, you have your own school that you can go to. So this case went all the way to the Supreme Court, and the court decided that state laws requiring separate but equal violated the Equal Protection Clause of the 14th Amendment. Because really, was a separate but equal? It was more dangerous for them to get there. It was further for them to get there. It was not really necessary. So the Brown versus Board of Education is a landmark Supreme Court case that overturned Plessy versus Ferguson. It said separate but equal is not okay. Separate but equal is unconstitutional. And it began the desegregation process of our schools. The next case that we're looking at also deals with 14th Amendment, but it is what we would, some folks would say is considered reverse discrimination. So in the Regents of the University of California versus Bakke, this was in the 1970s in California, and Alan Bakke was a white male who was applying to a medical school program at the University of California system. He was denied admission, and he petitioned the court saying, I had equal, if not better, test scores, GPAs, academic credentials than these minority students that they are admitting. And the University of California, Davis, did admit that they were considering race as they were trying to offer more spots, make a more diverse school, make a more diverse medical school, to provide more diverse opportunities for doctors. And in that, they ended up denying admission for an otherwise qualified individual. So in this case, Alan Bakke was denied admission. He petitioned the court, and the case went all the way to the Supreme Court. The Supreme Court ruled in favor of Bakke, and this is something in higher education, we look at this case very frequently. It says that in the process of admissions or in hiring practices, that the use of strict racial quotas is not allowed. It doesn't say we can't use race at all. Race can be considered one of many factors in determining whether or not a candidate is admissible or is the correct candidate to hire for a position. So it said racial quotas is not okay. Okay, the next case that we have, even more recent, Bush versus Gore. So this is dealing with the election in 2000. And this is dealing with right here in Florida, even in Palm Beach County. So in the election during 2000, the count in Florida, the count in the country for who would become our next president, whether it was George Bush or Al Gore, was extremely close. On election night, usually they can determine who is going to have the most electoral votes and who is going to become our next president. However, we went to bed on election night this year at this point, and did not know who was going to be the next president. And they said, it's going to come down to Florida, and whoever wins Florida is going to win the election. So when it came down to the votes, and if you think of the millions of votes just in the state of Florida, the millions upon millions of votes in the country, the difference in votes about who would become president came to under 2,000 votes in the state of Florida. So Florida statute requires a mandatory recount of votes if it is less than 0.5% of a difference between the candidates. So it went to a recount. So the problem here was the recount process was different in each county. So in some counties, they were able to machine feed the votes for a count. In some, they were hand counting to determine whether or not a person actually meant to vote for that person. So Bush took this, and this is one of those cases that goes directly to the Supreme Court, right? We don't want to wait to find out who's going to become president by going to lower level courts, and it is a federal issue. So this went directly to the Supreme Court, and the Supreme Court decided that because in Florida we were counting votes differently, the use of different standards to count votes violates the Equal Protection Clause of the 14th Amendment. So a note about the case Bush versus Gore. This was a case that wasn't in the original study guides that I had looked at. However, when folks have taken the test, it is often one of the options in the test. I have not seen this when I've taken the test, and I've taken it multiple times, as the correct answer. I have seen it as one of the answers, but I wanted you to have a sense of what the case is about in case you see it and you can either decide that maybe it is the right answer for the test version you have, or that you can rule it out by knowing more about the case. So that sums up our 14th Amendment cases. So we started with Dred Scott, which wasn't even dealing with 14th Amendment because they didn't even rule on Dred Scott because he wasn't a citizen, and it reversed the Missouri Compromise. Then we went into our first 14th Amendment case, which was Plessy versus Ferguson, which said separate but equal was okay. He can ride in the other rail car because it was separate but equal. Then Brown versus Board of Education overturned Plessy versus Ferguson and said separate but equal is not okay, and it desegregated the schools. And then we looked at Regents of University of California versus Bakke, which said race can be considered a deciding factor in admissions or hiring practices, but it has to be one of many factors, and you cannot have racial quotas. And then we looked at Bush versus Gore in the election, and that the counting of votes needed to be done equivalently in order to protect 14th Amendment equal protection rights. So we're still on the theme of voting, but we're going to a new case, and we're moving into our First Amendment cases. First Amendment has the most cases. I believe there are 6 out of the 22 cases that deal with First Amendment. That first case we're looking at is Citizens United versus the Federal Election Commission. So this is even more of a recent case, only 10 years ago, in 2010, and it is a case about campaign finance and showing of a video. So in this case, Hillary Clinton was ready to be in the Democratic primary in 2009, just before the primary election with Clinton and Barack Obama. And at the time, this interest group called Citizens United wanted to show a film and advertise that film just before the Democratic primary election that was very derogatory towards Hillary Clinton. So as you can imagine, Hillary Clinton's people and the Democratic Party felt that it would be very harmful for this to be shown. So they tried to stop it. So they called on some old law that said you can't show a film too close to an election period. So, and the other piece they were looking at was who was funding this. So Citizens United was funded by unions, by super wealthy people, and they were saying that who was funding the video and just the showing of the video both were a violation. So this case went directly to the Supreme Court because it is dealing with a federal issue, and the court held that 2 things. One is freedom of speech. They can show the broadcast, they can air this critical film of Hillary Clinton, that they can't stop that just because it's too close to an election, it would be harmful to the candidate. And also they said that who contributes to a campaign or where campaign finance dollars come from is protected speech. You as an individual, myself as an individual, or corporation or an organization has the right to put their spending money however they want, their campaign finance money however they want. Political spending is a form of protected speech under the First Amendment. So Citizens United versus Federal Election Commission, you may hear it Citizens United versus FEC, which stands for Federal Election Commission, deals with First Amendment. You can spend your political spending however you want, and they can't stop you from airing things during a political period. The next 2 cases we're going to deal with prayer. So you see, and you'll see this on many of our slides, there's a little red kind of hint at the top of that slide. So I'm going to have you take your 2 hands and make an upside down V. And hopefully they look to you sort of like prayer hands. Now I understand we are at a public university and we are not allowed to pray, but I am teaching you tricks to help you pass the civic literacy test. So in this case, Engel versus Vital, we have a V in Vital, and it deals with freedom of religion. The 2 cases that have V's in them both deal with something related to prayer. So if you remember from your amendments, the First Amendment deals with the free exercise clause, which is that everyone has the right to practice any religion they want or none at all. So in this case, in the 1960s, in the New York schools, public schools, the schools started with a non-denominational, which means non-religious based, not for a specific religion, prayer each day that was referencing God. So Engel was a student at the school and did not want to participate in this prayer, felt it was a violation of the First Amendment. So this case made it all the way up to the Supreme Court, and the Supreme Court agreed that school-initiated prayer in the public school system is a violation of the First Amendment. We cannot require people to pray in our public arenas, in our public schools. So when I have taken the test, and I've taken the civic literacy test a number of times, this is probably the #1 court case that comes up in the multiple choice responses. So knowing Engel versus Vital is really important. If you remember that upside down V means prayer, hopefully you'll remember this case has something to do with freedom of religion. The second case, we have West Virginia. So there's our V in Virginia. West Virginia State Board of Education versus Barnett. In this case, this was in the 1940s. The Barnetts were Jehovah's Witnesses. Jehovah's Witnesses typically do not follow traditional religious beliefs. They are not going to be praying, saying one nation under God. Even saluting a flag would be considered. We don't have a flag in here, do we? I usually do this presentation in a room with a flag so I can point out the flag. But they did not have to salute the flag. And but in the school, at the time, the Barnetts were told, you will say the Pledge of Allegiance or you will be expelled. They refused to do this, were being expelled for it, and the family took this case to court. After losing, they appealed, and the case went to the Supreme Court. And the courts agreed that the free speech clause of the First Amendment protects students from being forced to say to pledge a flag or to say anything about God. So again, although this is dealing with the Pledge of Allegiance, it is the religious belief and the symbolism behind praying to a flag. So V, we've got Engel versus Vital, and West Virginia State Board of Education versus Barnett. They both deal with prayer. The next two cases you see are going to have a T. So I encourage you to take your hands, just like we made prayer hands for Engel versus Vital and West Virginia versus the Barnetts. T is our symbol, and we're dealing with symbolic speech. So in Texas versus Johnson, Gregory Lee Johnson, this was back in the 80s under the Reagan administration during the Republican National Convention in Texas. Gregory Lee Johnson did not agree with the things that were being said there, and he protested by taking an American flag, dousing it with kerosene, and setting it on fire. So no one was hurt. This would have changed if someone was injured in this, but no one was hurt. This was just his way of expressing his displeasure with what was going on in the country and what was being proposed through this political Republican National Convention. There was a law in the state of Texas that said you cannot burn a flag. So Johnson was arrested and charged with desecration of a venerated object in violation of Texas law. So the Supreme Court, this went all the way, he was in court, he fought, he lost, it went to the Supreme Court, and the Supreme Court said that Johnson's actions were considered symbolic speech and is protected speech under the First Amendment. So we remember T for Texas, and that is our symbol. We will keep that T symbol when we go to our next case, Tinker versus Des Moines. In this case, the Tinkers were students during the Vietnam War era. So the Vietnam War was a very unpopular war. The Tinkers were in high school, and to show their displeasure of the war, they wore black armbands. That was their symbol. Just like in Texas versus Johnson, the symbol was the US flag. In this case, the black armband was a symbol of protest. So imagine being in a school, and there are people protesting the war, wearing black armbands and such, and then there are students there who maybe their older brother just got killed in war, or a teacher whose child just got sent off to war. There was a lot going on there. So the administration said, nope, you cannot wear anything to protest the war in school. And they refused to not wear these armbands in protest, and they were subsequently suspended. So this case went all the way to the Supreme Court, and the Tinkers said, I have a right to wear these armbands, and the court agreed with them. And they said that these armbands are considered symbolic speech in protest of the war. Remember our T symbol? And no one expects students to shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. So this is really interesting. So I highlighted this quote here because we are going to look at a couple of cases where limits in the school system are a little bit less protected than in other areas. But here in these two cases, so both in the two prayer cases, the two ones with the V, Engel versus Vital, and West Virginia versus Barnett, remember it said, nope, we can't make them pray in schools. And in these two cases, Texas versus Johnson, Tinker versus Des Moines, said symbolic speech is protected speech. Now we're going to move to a different case. So this is Hazelwood versus Kohlmeyer. I put two H's at the top, hopefully to help you remember. Hazelwood High School. Hazelwood is the name of the high school. The principal of Hazelwood East High School is the person who was in question here. So in this case, in this high school, there was a student-run newspaper, and the students published content for the paper. Before it went to press, the school administration reviewed the content and felt that there were things in it that they did not feel were appropriate to be printed. So they tried to pull the content, and the students in the school said, oh, First Amendment, freedom of the press, we can put what we want in here. So the school went all the way to the Supreme Court with this. The principal said, this is too important. We don't want this information going out there. So the Supreme Court agreed with the school principal and said that in a school setting that there are, for legitimate pedagogical, which means educational concerns, there are the ability to limit speech in that way, to limit what goes out in press. So basically they were trying to protect the greater needs of the school over the rights of the individual. So protecting the values of the school, protecting what other minors in the school would be reading was more important than the right for that person to publish what they want. Now, in a higher education setting, in a university setting where we're not dealing with minors or out in the real world, there are very few limits to freedom of speech. Again, as long as it's not hurting others, right? You can't publish anything if it's going to be liable. So in this case, Hazelwood versus Kohlmeyer, if you remember Hazelwood High, in this case, it limited their freedom of speech, that they could not put anything they wanted in the paper. The school administration had a right to censor some of that. Okay, that's it. That was 6 First Amendment cases. We are now moving on to Second Amendment. There's only one case dealing with Second Amendment. Hopefully you can remember that because DC has 2 letters and we're dealing with Second Amendment. DC versus Heller. So in this landmark Supreme Court case, Heller was a citizen in the District of Columbia where they had a handgun ban, and they restricted when you did have arms, what arms you could have, right? No handguns, and how you could store them. So you could have a rifle or a shotgun, but it had to be kept unloaded and disassembled or bound with a trigger lock. So imagine if the purpose of the Second Amendment was for the protection, right? It's the right to bear arms. If it was for the protection of the individual, imagine someone breaks into my home and I say, oh, excuse me a minute, well, I go and unlock my gun safe, take out my firearm and assemble it before we have a confrontation. Not practical. So Heller took this all the way to the Supreme Court, and the Supreme Court did decide that this was not allowing for the Second Amendment right, that the right to bear arms is not unlimited, that they will continue to regulate gun use and gun ownership, but it did say that the individual's right to possess a firearm said that they could have it where it would be accessible to them. So it did find for Heller. We're moving now to Fourth Amendment. So we have 2 cases dealing with Fourth Amendment. If you remember, Fourth Amendment deals with things like unusual search and seizure and having search warrants. So in this case, we're hopefully going to remember MAP has 4 letters, the way that the woman's name is spelled, M-A-P-P. Ohio has 4 letters, and we're dealing with Fourth Amendment, illegal search and seizure. So in this case, the police got a tip that Mrs. Mapp might be holding a person that was suspected in a bombing. So they went to Mrs. Mapp's home and said, we'd like to come in and search your home. She said, show me your search warrant. He said, we don't have a search warrant. They said, come back later when you have a warrant. So they left and they came back later. Pretending they had a search warrant, they kind of waved a paper in her face. They went into her home. During their search that was being conducted illegally because they did not have a proper search warrant, they actually found some pornographic materials, not relevant to even what they were looking for anyway, but they found a case with some pornographic materials. Ohio law was against having possession of obscene materials. She was subsequently charged and convicted of a crime. So her attorney said, well, you should not be able to use the materials that you found because it was an illegal search. So you should not be able to use that to convict her. So this went all the way to the Supreme Court, and the Supreme Court agreed with the attorney that evidence obtained through a search that was in violation of the Fourth Amendment, right? They went into her home without a proper search warrant, is inadmissible. So they threw out the evidence, and she was subsequently not found guilty. Her case was dismissed. The second case dealing with Fourth Amendment is New Jersey versus TLO. So I put a little tip up there that initials is going to equal a minor. So this is the only one of the 22 landmark Supreme Court cases that deals with initials. It is not the only case that deals with a minor. However, when someone sues someone else, it's either the name of the location, so in this example, New Jersey, or the person who is suing or being sued. Your full name will be used in that case, with the exception if a minor is involved, they have the right to redact the name and only use the initials. They didn't do that. Brown versus Board of Education, we know was Linda Brown was the minor. In West Virginia versus Barnett, we knew the Barnett, I'm confusing my cases, or we knew that they were minors. Doesn't matter, we don't have to redact the names. But in this case, New Jersey versus TLO, they took the option to use the initials, so we know it's a minor. In this case, it's Fourth Amendment. In New Jersey versus TLO, it is dealing with school privacy. Now, I don't want you to get confused. We did T dealt with symbolic speech. That is when the T is at the beginning of the case. Texas versus Johnson and Tinker versus Des Moines. In here, New Jersey versus TLO, we are not dealing with First Amendment, we're dealing with Fourth Amendment. So TLO was a minor in her school, and she was accused of, or suspected of smoking in the school bathroom. The school vice principal came up to her and said, "We think you were smoking in the bathroom. I want to search your backpack." She said, "Show me your search warrant." He says, "I don't have to show you my search warrant. Show me your backpack." He searched her backpack against her will and did find marijuana and some other cigarettes and other materials. So her family took this to court, and it went all the way to the Supreme Court saying they don't have a right. They couldn't use this evidence they found against me because it was an illegal search. And different from Mapp versus Ohio, where they said the evidence was thrown out because it was an illegal search, they said in this case that in a school setting that it did not violate the Constitution. There are more lenient standards for reasonableness in school searches. So for some of you who may have come here from Florida or high schools in the United States, you probably know that your school administration has the right to search your backpack and your locker, that those things are, when you're on school property, they have the right to do those things. So we now have 2 cases, and only 2 cases, where student rights are a little bit more limited, where they're limiting our Bill of Rights and our amendment rights. So that was in the First Amendment when we were dealing with Hazelwood versus Kohlmeyer, where the school had the ability to censor what was in a school newspaper. And for Fourth Amendment, New Jersey versus TLO, where the school has a right to do a search of a student's property. Okay, the next 2 cases are fun. We're going to make an M here for Miranda versus Arizona. So have you ever heard your Miranda rights? Hopefully never in person. Hopefully only because you watch lots of Law & Order and other crime shows like I do. So if you are familiar with your Miranda rights, you know you have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. That came from this case, Miranda versus Arizona. So this deals with both Fifth and Sixth Amendment. Fifth Amendment for self-incrimination, that's the part you have the right to remain silent. You don't have to incriminate yourself. You don't have to say anything that can make you seem guilty. Or Sixth Amendment, you have the right to an attorney. So in this case, Miranda versus Arizona, Ernesto Miranda was arrested as a suspect in a crime. They brought him into the police department and they started questioning him. They never told him any of his rights. They didn't tell him that he didn't have to talk. They didn't tell him he had the right to an attorney. So he got in there, the police started asking him questions, and he started spilling his guts and telling everything to the police officers. He admitted to the crime. So later, when he did get an attorney, the attorney probably did one of those, "Oh God, what did you do, Ernesto?" And then said, he went and said, "You should not be able to use anything that my client said," because he wasn't told his rights. He was later convicted of the crime, and because he confessed to it, and it went to the Supreme Court. The Supreme Court agreed that the police had not taken the proper steps to make sure Miranda was aware of his rights. So that is why the Miranda law came into account, right? But we're going to take it one step further. So we have this M for Miranda. We're going to turn that M upside down to our second case, which completes the Miranda warning. So Wainwright. So in Gideon versus Wainwright, and really the person's name was Gideon, but we're going to cheat a little and use the W in Wainwright because it's much cooler M to W than M to G. So in Gideon versus Wainwright, this is another very common case that you'll see when you're doing the Supreme Court cases on the civic literacy test. In this case, again, Gideon was arrested and he was told his rights. He was told, you have the right to remain silent and you have the right to an attorney. And he said, okay, I want an attorney. But he was poor and was unable to afford an attorney. He said, well, what is good is my right to an attorney if I can't have one because I'm poor, right? That's not equal protection. That is a total violation. It's saying that only the wealthy people can have this protection of the Constitution. So Gideon had no choice at the time, so he had to serve as his own lawyer, and he did a terrible job of it, and he ended up going to prison. While he was in prison, he handwrote a petition to the court, and it went to the U.S. Supreme Court, and they agreed to hear his case. The court unanimously agreed and ruled in Gideon's favor, saying the Sixth Amendment, which says a right to counsel, or right to an attorney, requires courts provide attorneys for criminal defendants who cannot otherwise afford that attorney. So that's why when you hear, and this is from Miranda, you have the right to remain silent, anything you say can and will be used against you. You have the right to an attorney. That's all from Miranda. If you cannot afford one, one will be provided for you, comes from Gideon versus Wainwright. That's this case. The way you maybe see this on a test is also asking about the public defender's office. So because of this case, which said that any criminal defendant who cannot afford an attorney, one must be provided for them, where are we going to get these attorneys? So this was the start of the public defender's offices. So pretty much all counties across the United States now have a division, an area within their court system of public defenders, and these are paid through the state to serve as counsel for people who cannot otherwise afford them. So if you see public defenders, you tie that to Gideon versus Wainwright. So those are the cases that really deal with issues related to the amendments. Now we're going to get into concepts. So Roe versus Wade, many of you may have heard of Roe v. Wade. So Jane Roe was an unmarried woman. She was, this was back in 1970. She lived in Texas and became pregnant. Texas law said it was illegal, it was a felony to have an abortion unless it was medically necessary. So at the time, this was in the late 60s and the early 70s, when abortion was illegal except for medically necessary reasons throughout most of the country, people were going into back rooms and having abortions, and it was really not safe for them. So Roe felt that this was unfair, that she had the right to decide what to do, and this went to probably one of the most controversial cases to date. This went to the Supreme Court, and the Supreme Court, so what it did is it said no, it didn't legalize abortion, which is how some people said it. They basically said that no state can prohibit first trimester abortions. So that means in the first trimester, which is the first, I'm thinking on my math right now, the first 12 weeks of your pregnancy, 12 to 13 weeks of pregnancy, that they cannot prevent abortions. No state can create a law that is superseding the federal law. So it, by all intents and purposes, made abortion in the first trimester legal in every state. No state could go against the federal law. Okay, next case, Korematsu versus United States. Hopefully you'll remember this because hopefully Korematsu sounds like an Asian sounding or Japanese name to you. So this was in 1941 after, in 1941, the Japanese bombed Pearl Harbor. This was the very beginning of World War II. So after Pearl Harbor was bombed, people in the United States were in a panic mode. And if someone near them looked Japanese, they were afraid that they would bring harm. So at the time, the United States created these internment camps, and required that all Japanese American citizens move to these internment camps. It was a way for the US to make sure we knew what they were up to and could keep our citizens safe. Korematsu did not want to move to an internment camp and felt it was a violation of his individual rights. So he refused to go and was convicted of violating an executive order. So this case went to the Supreme Court, and the government said that we needed to create these internment camps to protect the people. Korematsu said this is a violation of my rights, and the court actually agreed with the government and said that the need to protect the country was a greater priority than individual rights of Japanese and Japanese Americans. So again, I am not a constitutional law person, I am not a political scientist, but to me, I think that this case sets the expectation of things that are happening today in internment camps when we're separating immigrant families at the border and putting people in these camps, or even things like racial profiling that happened after 9/11, after September 11th in 2001. Anyone that looked like they could be from Middle Eastern descent may have been taken aside and questioned or had extra screening at an airport. And I think that this is the case that probably really allows that to continue to happen today. Okay, I think we only have 4 cases left, so hang in there with me. This case, you will definitely see on your civic literacy test. I can almost guarantee it. It is very an important case, and not that they all aren't, but it is one that you will commonly see. Marbury versus Madison. So just a quick history lesson of what was happening here. So John Adams was our 2nd president, and he was leaving office. Thomas Jefferson was going to become our 3rd president. They were from 2 totally different political parties. They did not like each other. So before Adams left his presidency, he decided that he was going to commission about 12 different justices of the peace and other similar appointments. If you remember, when you make those appointments for federal offices and things like that, it has to get approved by the Senate. So this got rushed through. It was the end of Adams' presidency. The Senate quickly approved these, and most of them were sworn into office before Adams left for the end of his term. But Marbury was one that was not able to be sworn in before Thomas Jefferson was sworn in as president. So Jefferson's Secretary of State, Madison, needed to deliver the documentation to Marbury so that he would be able to get sworn in, and Madison refused to do that. So this went to the Supreme Court directly, and the Supreme Court looked at 2 concepts. One, they said the supremacy clause. Remember, we talked about the Constitution is a supreme law of the land. The Constitution is the law, because at this time, the United States was new. We were wondering, what is this Constitution? Is it just a bunch of ideas, or is it really law? So in this case, they said the supremacy clause, this is the law of the land, and you must follow it, and these are the rules, and we must follow these rules. And this idea of judicial review, which said the Supreme Court was created to rule on these decisions. So it says, in the Marbury versus Madison, they said you have to turn over the papers, but that wasn't the important piece of it. It did say that the Constitution is the supreme law of the land, not just a bunch of ideas, and that the Supreme Court has the right to review and rule on these different elements of the Constitution. The next one I don't have great ways to remember, but it is an important one that you'll see often, Gibbons versus Ogden. You might remember because Gibbons has 2 B's and it deals with 2 boats. So this again, just a few years after the United States was formed and the Constitution was ratified. So now the federal government was trying to figure out how to get themselves set up, but so were the state governments, and so was business and trade and commerce and everything happening in the states. So in New York, there was a steamboat company, and they were actively involved in trade within New York. And there was a steamboat company that Ogden ran in New Jersey. So they were running in the waters between New York and New Jersey. So New York declared that their person had a monopoly over, Gibbons had a monopoly over trade and commerce in the steamboat business. So he was ruling all the waters outside of New York. Well, Ogden came in and said, well, you can't decide that. This water is in between our states. So this went to the Supreme Court, and the Supreme Court determined that within the Constitution, there's a clause called the Commerce Clause. The Commerce Clause of the Constitution allows the federal government the power to determine how interstate commerce is conducted. So New York can determine how trade is within their borders. New Jersey can determine how trade is within their borders. But when it comes to anything outside of the borders of the state, it falls under the auspices of the Constitution and the United States government. So Gibbons versus Ogden deals with Commerce Clause. You can remember boats. The commerce was conducted. Commerce is trade. Trade by steamboat. 2 left. Yep, just checking. Okay, McCulloch versus Maryland. So I alluded to this case if you watched the video for the first workshop. So in McCulloch versus Maryland, when we set up the Constitution in 1787, our founding fathers tried to think of every scenario they could, but there was no way in 1787 they could think of everything and put everything into this one document that would be the future of our country. They didn't deal with technology in there, right? There was no cell phones, there were no computers, there were a lot of things they didn't necessarily have in there. So in this case, right after and this was back in the early 1800s, the US was setting up national banks. They said, okay, in our powers in the Constitution, we have the power to tax, and we have the power to print money. We have all of these powers, but we can't do these things properly without having a place to store and securely hold our money. So they were creating national banks. Well, at the same time, the states were trying to set up and do what they had to do. One of those things was to collect taxes. So in Maryland, the federal government set up a bank, a federal bank in Maryland, to be able to collect taxes, store money, get money to the citizens in Maryland and across the states. So the people in Maryland said, okay, we're going to, or the state government in Maryland said, we're going to tax all of the businesses on our land. So they brought a tax bill to James McCulloch, who was a branch employee at the federal bank. So this representative from the tax office from the state of Maryland brought McCulloch a tax bill and said, you need to pay taxes because you have a business in Maryland. He said, I'm not going to pay taxes. We're part of the US government. And they said, well, if you don't pay your taxes, you can't operate in Maryland. So this went to the Supreme Court, and the Supreme Court determined Congress has what we call implied powers. Remember, we talked about things that are necessary and proper, things, the elastic clause, things that can stretch. So things that are implied for them to do, things they have to do that are necessary and proper to carry out the business that is defined in the Constitution. So the court found that they have implied powers, broad power to implement the enumerated powers. Those are the powers that are spelled out in the Constitution. So they were allowed to create a national bank, even though the Constitution didn't explicitly say that they can create a bank, but it was necessary for them to do that. It was an implied power because they have the power to do other things that necessitated opening a bank. And that Maryland's taxing of that was unconstitutional because they couldn't tax the federal government. So McCulloch versus Maryland is another one you are very likely to see on there. So remembering implied powers. Not everything is spelled out, and it deals with the bank employees. The last case, US versus Nixon, we also mentioned if you watched the video for the first workshop. And in this case, this was late 1960s. President Nixon was obviously the president, and he was involved in some scandals that were going on. They found out that Nixon had some tape recordings that he had had in the Oval Office, and they asked him for the recordings. He refused to give them. So a subpoena was issued. So if any of you ever receive a subpoena, it is a court-ordered document that you must do what the subpoena says. So you might get a subpoena that says you have to appear in court as a witness. You have no choice. You must do that. So in this case, Nixon received a subpoena saying he had to turn over the tapes that were in his possession, and he refused to do so. He said that it would be bad for the country to do that. So this went because, again, this is dealing with a president. It goes directly to the Supreme Court. There are no lower courts that would see that. And the court decided that he had to follow the subpoena. He had to turn over the evidence in the subpoena. No one is above the law. Even the president is bound by whatever is in the law. Executive privilege is not limitless. And the tapes were released. He then knew he was in trouble. they were going to follow through with impeachment hearings and criminal proceedings, and he ended up resigning. So Nixon is the only president to resign. But if you see this question, if you see U.S. versus Nixon on the civic literacy test, it will most likely be asked in terms of what was the major finding of it, and it is no one is above the law, which we also know as the rule of law. All right, that was 22 minutes, and we are 50 minutes into this workshop. Sorry, 22 cases. I've been talking too long. 22 cases in 50 minutes, not bad. So we're going to do a super quick review, and then we're going to give you that test, the post-test, to see how many of these cases you can answer correctly on a practice test. So remember, we said there were 6 cases about First Amendment. This is going back about a half hour ago. So the first case, Citizens United versus the Federal Election Commission, or FEC. This was the Hillary Clinton during the Democratic national primaries, and she did not want some really inflammatory videos about her released. She tried to stop it, saying it was too close to the primary and that the funding of these cases were inappropriate, not that the cases, the funding of the video was inappropriate. And the Supreme Court found that, one, it is a violation of First Amendment to limit when they can show the video, and what political dollars are spent is protected speech, that different unions, different individuals, different businesses can put their political spending however they choose. That is protected speech. Our next 2 cases you see on here both have V's. So hopefully you remember upside down V, looks a little like prayer hands. Engel versus Fatal, that said that they could not have that non-denominational prayer in the schools. And West Virginia School Board of Education versus Barnett, that one said that Jehovah's Witnesses, they did not have to do the Pledge of Allegiance. They're requiring individuals to pledge allegiance was a violation of First Amendment, free exercise clause of the First Amendment. Hazelwood versus Kohlmeyer, that is the only First Amendment case that limited speech slightly. So remember Hazelwood High, they had a school newspaper. The assistant principal and principal wanted to limit what was being put out in the school paper, and the students cried, no, that's censorship. And the courts ruled, no, the school administration, because they are dealing with minors, does have the right to limit the speech if there is a truly valid pedagogical reason to do so. The next 2 cases, we have our T's for symbolic speech, Texas versus Johnson. That was the flag burning, said that burning a flag, while it's not a great thing to do, as long as it doesn't physically harm someone, it is protected symbolic speech. And Tinker versus Des Moines, remember they wore the black armbands in protest of the Vietnam War, and those black armbands were considered protected speech. The next case, DC, 2 letters, DC versus Heller, we know is Second Amendment. That was the case where in the District of Columbia, they had the handgun ban and said that Heller or all residents could keep a firearm had to be locked up and disassembled or not loaded with ammunition. And he said, well, how is that going to protect me? And the courts agreed. And although there are still limits, and they can still put limits on gun control, but it did allow them to keep their weapon as long as it was secured, accessible. Fourth Amendment, we have 2 cases, MAP 4 letters, Ohio 4 letters. So we know that was the one where they wanted to search her home. They didn't have a search warrant. They came back later with a fake search warrant. And later the court decided that anything they found during that search was found illegally, and all of it was thrown out. New Jersey versus TLO was the second case that dealt with something in the school where they limited protections for the student. So this was where they searched the girl's locker or her backpack, and they found marijuana and cigarettes. And they said that searches in schools do not have to, there are more lenient standards for searches in schools. The schools don't have to abide by such a high level of having a warrant and probable cause and all that. Fifth and Sixth Amendment, Miranda versus Arizona. So that was you have the right to remain silent. Anything you say can and will be used against you. And you have the right to an attorney. Gideon versus Wainwright added, if you cannot afford one will be provided for you. And remember, because they couldn't afford an attorney, that created the beginning of the Public Defender's Office. We're almost done. 13th and 14th Amendment. So slaves were freed, right, by the 13th Amendment, and then the 14th Amendment tried to create things to make up for slavery. to make things more equal. So Plessy versus Ferguson, that was Homer Plessy had to ride in a separate rail car because he was 1/8 Black, and the court found separate but equal is okay. That was overturned. Brown versus Board of Education. Remember, the brown girls had to walk through a dangerous area past a white school to go to an all-black school, and the court overturned Plessy versus Ferguson, said separate but equal is not okay, that Browns were able to go to the white school, and it started the beginning of desegregation. Regents of the University of California versus Bakke, remember equal protection, dealing with race and admissions. So that was the one that said race can be used as one of many factors for both admissions or hiring, but it cannot be used as a primary factor. And some other cases that dealt with concepts, not necessarily amendments. Dred Scott versus Sanford, remember Dred Scott's owner died, he was a slave, and they moved to a free state, he wanted to be free. The court would not even rule on it. It was dreadful because they said he wasn't even a citizen, so they couldn't make a ruling. Gibbons versus Ogden, 2 Bs, 2 boats, right? The Commerce Clause. So Gibbons versus Ogden, they had the steamboats in New York and New Jersey, and they said, the federal government said, we have the right, based on the Commerce Clause in the Constitution, that we can regulate trade between states. Korematsu versus US dealt with the Japanese relocation after the bombing of Pearl Harbor and said that the Japanese internment camps were legal because the protection of the whole of the US population was more important than the rights of the individual. Marbury versus Madison, remember Adams leaving the presidency, Jefferson coming into the presidency. Madison was holding back the papers to allow Marbury to take office. And the court said, one, that we have the right to review this and make decisions. That's called judicial review. And that you have to abide by the Constitution. The Constitution is the supreme law of the land. McCulloch versus Maryland, that was the banks. So because the Constitution says that we can print money, because the Constitution says we can collect taxes, in implied powers, we can also create banks. So the state of Maryland was not able to tax us for creating a national bank in Maryland. Roe v. Wade, the federal government set that no state could have a contradictory law that prohibited first trimester abortions. And finally, US versus Nixon, no one is above the law, the rule of law. All right, so at this point, there is a practice test. I'm going to ask you, I'm gonna switch over to our doc cam. I'm going to ask you, if you have already printed out, to give yourself a few minutes to take this practice test on the landmark Supreme Court cases. There are only 16 questions. You can pause this video and come back. As soon as you are done, we will go over the answers, sum up, and we'll be finished with the second workshop. So I'll see you in a few minutes. Okay, hopefully you've taken your time and completed the quiz, that you aren't just waiting for me to give you the answers. But we'll go ahead and go over the answers to the landmark Supreme Court case quiz. Question 1, this case established the policy of judicial review. We just spoke about that. The answer is Marbury versus Madison. So when you see these multiple choice questions, if there is a case we did not go over, it is very unlikely it is the correct answer. So in this case, you see Morse versus Frederick. That is a true case. It is not the correct answer here. We did not go over it. So it is unlikely, if you see that case, that it will be the correct one. Same with the next question, Bethel School District versus Frazier. Real case, we didn't go over it. So hopefully through process of elimination, even if you're not sure, you can limit the ones that you think that you know are not the right answer. This case ended segregation in public schools. Brown versus Board of Education. Question 3, this case advocated free speech in the schools in the form of an anti-war protest. Correct answer, remember T is our symbol. Our symbol was the black armband. It's Tinker versus Des Moines. Question 4, this case guaranteed certain rights for individuals being arrested. Out of the choices given, D, Miranda versus Arizona would be the correct answer. If that wasn't a choice there, but Gideon versus Wainwright was an answer, that could be the correct answer. Question 5, this decision allowed for women to have abortions, at least in the first trimester. Answer is A, Roe v. Wade. Question 6, in Plessy versus Ferguson, the Supreme Court ruled that segregation was, remember Plessy versus Ferguson was the first one, said That was the Railcar Act, that segregation is legal as long as the facilities are equal. That is C. In which case overturned it? That would be Brown versus Board of Education, that separate but equal was not okay, was not constitutional. Question 7, this case determined flag burning is protected by free speech. So we remember again, our free speech, our symbol is a T. My T here. Texas versus Johnson. In Texas versus Johnson, he burned the flag, and while it's not a lovely thing to do, it is protected speech. Question 8, this case determined public prayer and Bible readings in school violates the First Amendment. That's our prayer hands, Engel versus Vital. Question 9, sorry. This case determines schools only need reasonable suspicion, not a warrant, to search students as a necessary step to provide a safe learning environment. We remember we were dealing with minors here, so we have the initials, New Jersey versus TLO. D is the correct answer. Question 10, in this case, the court ruled the policy of using quotas or a predetermined number based on race or gender as part of affirmative action in hiring or admission practices is unconstitutional. That's A, Regents of the University of California versus Bakke. Question 11, during World War II, the Supreme Court ruled that relocation of Japanese American citizens to internment camps was constitutional. In which case? Korematsu versus US, A. Question 12, this 1857 ruling declared slaves are property and not citizens, and it nullified the Missouri Compromise of 1820. That's A, Dred Scott versus Sanford. Question 13, in Tinker versus Des Moines, the Tinkers were suspended from school for wearing black armbands. B, that is their protected speech. Question 14, which lessons did future U.S. leaders learn from 1974 Supreme Court case U.S. versus Nixon? The president is accountable for obeying laws, right? No one is above the law. Yes, even the president has to obey the law. Question 15, states must pay for public defenders as a result of which U.S. Supreme Court case? The correct answer for that, Gideon versus Wainwright. So remember, you have the right to an attorney if one cannot be provided. It will be provided for, if you cannot afford an attorney, one will be provided for you. That created the Public Defender's Office. Question 16, evidence that is illegally obtained by the state may not be used against a defendant in court based on which case? So remember the illegal search and seizure, that's from the Fourth Amendment, Amendment 4, MAP has 4 letters, Ohio has 4 letters, so the correct answer is C, MAP v. Ohio. All right, so that is 16 questions. So how did you do? If you got at least 9 of them right, you are at 60% and will easily pass that portion of your civic literacy test. So congratulations. A couple of tips for test taking. So ways that you may see these, so some of them will be straightforward. It might say, which amendment did this case deal with? So it might show MAP v. Ohio and say which amendment was the primary amendment that this case dealt with, and you should know that it's Fourth Amendment, illegal search and seizure. Or Hazelwood versus Kohlmeyer, what amendment did that deal with? It was First Amendment protected speech. Tinker versus Des Moines, First Amendment free speech. Engel versus Vital, First Amendment. So knowing what the case is, what amendment it deals with, but you may also see things, I mentioned in the last workshop, where they'll give a synopsis of a case we didn't go over and ask you what concept it ties to, what ideal it's tying to, what amendment it's tying to. So just read carefully. A lot of times if you read things, you'll know. They might give you an excerpt from a letter from 1746. I made that year up, I don't know. But a letter that was written, from a colonist or at the time. And it might say which principle in our current government was in response to the ideas in that letter. If you know the content from these workshops, you can answer those questions. Again, they're all multiple choice, so you can usually narrow down a couple of incorrect answers, and you should be doing great. So you have completed hopefully the first 2 workshops. There is one additional workshop, workshop 3, goes over practice tests like this, goes over a little bit more in detail about the answers to some questions, because if you can know them when they're not in a multiple choice format, You'll know the concept, so when they ask the questions differently, you'll be able to more easily answer them. So you certainly would want to view the third workshop. The last thing I will show you is if you did not watch on the last video, how to sign up for the civic literacy test. Go to www.fau.edu/, I'm typing too fast, testing. When you go here, register for your exams online. You can click it here or register for your exam here. I'll click it here this time. Lists all the different tests. You register for civic literacy test. Gives you some information about the test. The minimum score that you need is a 60. If you get a 62 on the test, you have passed. Your 62 does not show up anywhere. It just shows as requirement satisfied. So don't stress about what your score is. You just need to pass. Worst comes to worst, if for some reason you had a bad day and you didn't pass it, you can take it again even as early as the next day. It is still free. Your failing grade doesn't show up anywhere. So this is really nothing to worry about, but a great thing to get done and get done quickly. Take the tests soon after you've done the workshops while this information is fresh in your head. It reminds you what you should and should not bring to the test. Definitely bring your ID. You don't need much of anything else. It is computer-based. It is actually through Canvas, so you're familiar with Canvas through this workshop and your other classes. They will log you in. You will take the test there. They will not allow you to bring in a hoodie, a sweater, gum, food, drink, not even a bottle of water. You can't have a watch on. They're very strict. No cell phones. Click on to schedule your exam. You're going to choose the exam, which is the civic literacy test. You get to pick it twice. It gives you a description. It's 120 minutes long. Remember, you do not have to stay the full 120 minutes. As soon as you're done, you can leave. You do want to make sure you have your ID with you. You pick your date. Once you pick what date you'd like to take it, you select what time you would like to take it. You put in your information, your name, your Z number, your email, agree to the guidelines, add it to your cart, and then you are going to make sure you submit it. Good luck, and we'll see you at the third workshop. Thank you. Hello? Yes, who's calling? Yeah, can you, just hold on one second. I'm just finishing.